The day my company was supposed to receive $2 million in funding, I sat across from my brother in a glass-walled conference room in downtown Miami and watched him smile while a lawyer slid a contract toward me. Page 7 listed my ownership at 5%. I had written the code, built the product, and spent 3 years of my life creating everything described in that document. My brother had simply learned how to put his name on it. My name is Maya Callahan, and this is the story of how I built a company from scratch, how my brother tried to take everything I created, and how the truth found its way back when neither of us expected it. If this story hits close to home, subscribe and drop a like right now. It helps more people find stories like this one. Ryan is 4 years older than me. We grew up in a small house in Riverside, California, where our dad worked in logistics and our mom taught middle school math. There was nothing dramatic about our childhood. We weren't rich, we weren't struggling, we were just a regular family getting through the week. But even back then, Ryan and I were wired completely differently. Ryan could walk into any room and make people want to listen to him. He had natural confidence, the kind that pulls attention without asking for it. He always knew what to say and when to say it. I was the opposite. I was the one staying home on Friday nights, taking apart old laptops, spending weekends reading about software architecture while other kids were at the beach. I wasn't antisocial. I just found something I loved early and never wanted to stop. By the time I graduated with a computer science degree, I had already built 2 small apps on my own. Neither made money, but both taught me something important. The second one showed me I could solve a problem that thousands of small businesses had, they just didn't know a solution existed yet. That idea stayed with me through the 2 years I spent working at a software firm in San Diego, saving every dollar I could while building something new every evening after work. The product was a workflow automation tool built specifically for small and mid-sized logistics companies. I understood the industry from growing up around my father's work, and I knew exactly where the software gap was. Existing tools were either too expensive, too complicated, or designed for corporations 10 times larger than the companies that actually needed help. I spent nearly 3 years filling that gap. Ryan was living in Miami by then, working in tech sales. We talked on the phone every few weeks and saw each other at holidays. He knew I was building something, but I kept the details to myself until I had something real to show. When I finally demonstrated a working version of the platform, he went quiet for a long moment. Then he said it was the most impressive thing he had ever seen and that he knew people who would pay for it immediately. He asked if he could come on board as a partner. I said yes without hesitation. He was my brother, he was right that I needed someone who could sell, and I trusted him completely. We agreed on 50-50 and shook hands on it, planning to make everything official once the company was properly formed. That handshake felt like the beginning of everything we had ever talked about building together. What I didn't understand yet was that Ryan had already started thinking about what came after the beginning, and his version of that future looked nothing like mine. Ryan joined the company in the spring, and for the first several months, everything felt exactly the way I had hoped it would. He moved back to California and set up a small sales office in Los Angeles while I ran product development from our main workspace in Riverside. We split the responsibilities cleanly. I built, he sold. It was the kind of partnership that made sense on paper and felt even better in practice, at least in the beginning. Ryan had a gift for making people feel like they were the most important person in the room. He could take a 45-minute product demo and turn it into a 2-hour conversation that ended with a handshake and a follow-up meeting already scheduled. Within his first 3 months, he had brought in our first 8 paying clients, all small logistics companies along the West Coast who had been struggling with exactly the problem our platform solved. Every new client felt like proof that we were building something real. I was working 15-hour days during that period, pushing the platform forward as fast as I could. Every piece of client feedback that came back from Ryan's meetings turned into a new feature or an improvement I stayed up late to build. The product was getting stronger every week, and the numbers were starting to reflect it. Client retention was high, referrals were coming in without us asking, and the revenue, while still modest, was growing in a direction that was hard to ignore. It was around that time that Ryan started attending industry conferences. He was good at them in a way I never would have been: relaxed, memorable, the kind of person investors gravitate toward at networking events. He started coming back from those trips with new contacts, new energy, and stories about conversations with people who were interested in what we were building. I encouraged all of it because that was his role and he was doing it well. But somewhere in those months, something shifted in the way Ryan talked about the company. It was subtle enough that I almost didn't catch it at first. In early conversations with potential partners, he always said we. Our platform, our team, what we built. Gradually, without any single moment I could point to, the language changed. He started saying my company in interviews. He started describing the product in pitches as something he had developed. I heard a recording of one conference panel where a moderator asked him how he came up with the core technology, and Ryan gave a 4-minute answer that never once mentioned my name. I brought it up with him directly one evening over the phone. I kept the conversation calm because I didn't want to damage what we had built together over something that might have been careless rather than calculated. He laughed it off and told me I was overthinking it, that everyone in sales talked that way, that the point was to make investors feel confident and a single founder narrative was simply easier to sell. He said it didn't mean anything about what we actually were to each other or to the company. I wanted to believe him, so I did. What I didn't know at the time was that Ryan had already made his first move. A few weeks before that phone call, he had quietly hired a corporate attorney in Miami, not the firm we had agreed to use together, a different one I had never heard of. I found out about it later through a mutual contact who had seen Ryan at a lunch meeting with the lawyer and assumed I already knew. When I asked Ryan about it, he said he was just getting some general legal advice about investor structures and that he had planned to loop me in once there was anything worth discussing. That explanation felt thin, but I had no proof of anything specific, so I let it go. Looking back now, that was the moment the plan was already in motion. While I was heads down building the product and trusting that our partnership meant what I thought it meant, Ryan was sitting across from attorneys and learning exactly what it would take to restructure a company without the other founder noticing until it was too late. I was focused entirely on the work. He was focused on something else entirely. The investor's name was Garrett Holt. Ryan mentioned him for the first time on a Tuesday evening call, describing him as a serious player in the logistics tech space who had already backed 3 successful platforms and was actively looking for his next deal. Ryan said Garrett had seen a product demo at a conference in Miami and reached out directly, that the conversation had gone well, and that Garrett wanted to schedule a formal meeting with both of us the following month. I remember feeling genuinely excited that night. $2 million in early-stage funding would have changed everything: faster development, a real team, the ability to stop running on fumes and actually scale the product the way it deserved to be scaled. I spent the next 3 weeks preparing. I rebuilt the demo from scratch to make sure every feature was sharp and every number was defensible. I put together a full technical breakdown of the platform's architecture, a competitive analysis, a 12-month product roadmap, and a financial model built around realistic growth assumptions. I wanted Garrett to understand not just what the product did, but exactly why it worked and where it was going. By the time the meeting date arrived, I had a presentation I was genuinely proud of. The meeting was held at Garrett's office in Miami. Ryan and I flew out together, and on the plane he seemed relaxed and confident in a way that I read as a good sign. Garrett was polished and direct, the kind of investor who asked sharp questions and listened carefully to the answers. The meeting lasted 2 hours. I walked Garrett through the technical side of the platform in detail, explained the core problems it solved, and showed him exactly how the product had performed with our existing clients. He asked difficult questions, and I answered every one of them. By the time we walked out of that building, Ryan was saying he could feel it, that Garrett was going to move forward. He was right. Garrett called 3 days later and said he was ready to make an offer. Ryan took that call alone. He told me about it afterward and said Garrett had proposed $2 million for a 30% equity stake, which was a strong offer at our stage, and that he had told Garrett we would review the terms and get back to him within the week. I told Ryan it sounded like exactly what we needed and that we should get our lawyer involved immediately to start reviewing the term sheet. Ryan agreed. He said he would handle the coordination with legal and keep me updated as the documents came together. Over the next 2 weeks, he sent me occasional short messages saying things were progressing and that he would send the draft agreement over as soon as it was ready for review. I was busy during that period pushing out a major platform update, and I trusted that Ryan was managing his side of things the way I was managing mine. I never asked to see the draft early. I assumed I would see everything when it was ready to be finalized, because that was what partners did. What was actually happening during those 2 weeks was something I could not have imagined at the time. Ryan was meeting privately with Garrett and a corporate attorney to restructure the company's ownership before the investment documents were ever drafted. The plan was clean and deliberate. By quietly filing amended articles of incorporation, Ryan had reclassified the equity in the company and reduced my stake from 50% to 5%. He had removed my name from the board of directors entirely. On paper, as of those filings, I was a minor shareholder with no governance rights and no meaningful claim to the company's direction or future value. Garrett knew. That much became clear to me later. He had made it a condition of his investment that the company have a single controlling founder, and Ryan had offered him exactly that. Whether Garrett understood the full picture of what Ryan was doing or simply didn't ask questions he didn't want answered, I can't say with certainty. What I do know is that he signed off on a structure that was built on documents I had never seen and agreements I had never made. Ryan scheduled the final signing for a Thursday morning in downtown Miami. He told me it was a formality, that everything was in order, and that we just needed to show up and put pen to paper. I booked my flight the night before, feeling nothing but relief that the months of work and waiting were finally coming to an end. I had no idea I was flying to Miami to find out that the company I had spent 3 years building had already been taken from me before I ever walked through the door. I read page 7 3 times before I fully accepted what I was looking at. 5%. Not 50. Not even close to 50. 5% of a company I had started alone, built alone, and carried through 3 years of late nights and early mornings before Ryan ever came into the picture. I set the document down on the table and looked across at my brother. He was watching me with an expression I had never seen on his face before, calm in a way that didn't belong in that moment, the kind of calm that only exists when someone has already rehearsed how they plan to handle a conversation they knew was coming. Garrett was sitting at the head of the table. He glanced down at the papers in front of him and said nothing. I asked Ryan quietly what I was looking at. He said the structure had been adjusted to meet investor requirements, that a single controlling shareholder was standard for this kind of deal, and that 5% was still meaningful equity that would be worth something real once the company scaled. He used the word adjusted the way someone uses a word when they have practiced using it instead of a more accurate one. He didn't raise his voice. He didn't apologize. He just sat there and explained the thing he had done to me as if it were a reasonable business decision that I should be mature enough to understand. I told him clearly that I had never agreed to any of this, and that these documents did not reflect our partnership. He said the original agreement had been informal, that nothing had ever been legally documented, and that the company had evolved past the point where a 50-50 split made sense given the roles each of us had played. He said he had done the work of building the investor relationship and that the equity structure reflected that contribution. Then he looked at me and said that if I wanted to stay involved, 5% was a fair place to start. I stood up, picked up my copy of the contract, and walked out of that conference room without signing a single page. The elevator ride down to the lobby felt like it lasted an hour. I stood on the sidewalk outside the building in the Miami heat and tried to organize my thoughts into something I could act on rather than something that would pull me under. The betrayal was so complete and so deliberate that part of my mind was still searching for an explanation that made it less than what it clearly was. But there was no other explanation. Ryan had planned this carefully, executed it quietly, and flown me to Miami expecting that I would sit down, see my name on a document, and sign it because what other choice did I have at that point? He had miscalculated one thing. I had kept everything. Every version of the codebase was saved and timestamped going back to the first prototype I had built in my apartment in San Diego. Every design document, Every technical specification, every architecture diagram I had drawn before Ryan ever joined the company was stored on a personal hard drive that had never been connected to any shared company system. 3 years of development history, all of it dated, all of it tied to my accounts and my devices, existed completely outside of anything Ryan could access or alter. I drove back to the hotel, sat down at the desk in my room, and called the only person I trusted completely at that moment, my college roommate Dana, who had gone on to become a corporate attorney in San Francisco. I told her everything that had happened from the beginning. She listened without interrupting until I finished, and then she was quiet for a moment before she told me exactly what I needed to hear. She said that if the original platform had been created entirely by me before Ryan joined, and if I had documentation proving that timeline, then Ryan had not just pushed me out of a partnership. He had attempted to strip me of intellectual property that legally belonged to me and me alone. She said I needed to get in front of an IP attorney before Ryan's deal with Garrett moved any further. I was on the phone with an intellectual property lawyer in Los Angeles by 9 o'clock that same evening. I explained the situation, described the documentation I had, and answered every question he asked as precisely as I could. By the end of the call, he told me we had something strong and that I should overnight him the hard drive immediately so his team could begin a full documentation review. I packed it that night and shipped it before the Miami post office closed the next morning. Ryan sent me a text that evening. It said he hoped I would take some time to think clearly and that he believed we could still find a way to work this out that made sense for everyone. I read it once and put my phone face down on the nightstand. There was nothing to respond to. Every minute I spent reacting to Ryan was a minute I wasn't spending building the case that was going to decide what happened next. I flew back to California the following morning with nothing resolved and everything in motion. The anger I felt was real, but I had already made the decision not to let it make choices for me. I had spent 3 years building something that worked because I stayed focused and ignored every distraction. I was going to need that same discipline now more than I had ever needed it before, because what was coming next was not going to be quick and it was not going to be easy. And Ryan was already several steps ahead of me in a game I had only just realized we were playing. The IP attorney's name was Conrad Ellis, and he called me 4 days after I overnight him the hard drive. He had spent those 4 days with 2 members of his team going through every file, every timestamp, every version history, and system log on that drive. When he called, his voice carried the kind of measured confidence that lawyers use when they know exactly where they stand. He told me the documentation was exceptionally clean. The earliest files dated back 38 months, well before Ryan had ever been introduced to the product in any capacity. The development history was continuous, consistent, and tied entirely to my personal accounts and devices. There was no gap, no ambiguity, and no point in the timeline where Ryan's involvement could be credibly inserted into the creation of the core technology. Conrad explained what that meant in plain terms. The platform, the code, the architecture, the proprietary workflow system at its center was my intellectual property. Ryan had not created any part of it. His name appeared nowhere in the original development record. What Ryan had done by restructuring the company and presenting it to an investor as his own creation was not simply a breach of our informal partnership agreement. It was a misappropriation of intellectual property, and it exposed both him and Garrett Holt to serious legal liability if the investment deal closed on the terms they had structured. Conrad recommended we move quickly. The longer the deal sat unsigned, the more time Ryan had to find ways to complicate the situation. We filed a formal intellectual property claim that same week, asserting my ownership of the core technology and requesting an immediate injunction that would prevent the company from transferring or licensing the platform to any third party, including Garrett Holt, until the matter was resolved. The filing went to a federal court in California, and because the documentation supporting the claim was so thorough, the injunction was granted within 72 hours. Ryan found out about the injunction on a Friday afternoon. I know this because he called me 11 times between 3 and 6 o'clock that day. I let every call go to voicemail. His messages started formal and businesslike, shifted to frustrated, and by the last two had a quality to them I had never heard from my brother before. Something close to panic sitting just underneath the surface of words that were still trying to sound controlled. He said I was making a mistake. He said I was going to destroy everything we had built. He said we needed to talk before this went somewhere neither of us could come back from. I called him back that evening, not because I wanted to negotiate, but because Conrad had advised me to document every communication from that point forward and to keep Ryan talking rather than going dark. I kept the conversation short and factual. I told Ryan I was aware of what he had filed with the state, I was aware of what he had represented to Garrett, and I was aware that none of it had been done with my knowledge or consent. I told him my attorney would be in touch with his. Then I ended the call. What happened over the next 3 weeks moved faster than I had expected. Garrett Holt's legal team contacted Conrad almost immediately after the injunction was served. Garrett's attorneys were not interested in defending a $2 million investment that was now sitting on top of an active intellectual property dispute. They had conducted their own due diligence on the platform before agreeing to the deal, and that due diligence had not surfaced anything about the ownership timeline because Ryan had never given them reason to look. Now that the claim was filed and the documentation was public record, they were looking at a situation where the core asset of the company they were about to fund might not legally belong to the person they had agreed to fund it with. Garrett suspended the deal pending resolution of the dispute. That single decision collapsed everything Ryan had built toward over the previous several months. Without the investment closing, the restructured company had no funding, no operational runway, and no path forward. The clients we had spent months acquiring were still there, but they were contracted to a platform that was now the subject of active litigation, and word travels fast in a small industry. Ryan hired a litigation attorney and filed a counter-response arguing that the partnership had been a joint venture from its inception and that his contributions in sales and business development gave him co-ownership of the resulting intellectual property. Conrad had anticipated this argument and had prepared for it thoroughly. The development timestamps told one story with complete clarity. The platform had existed in fully functional form before Ryan joined, and every significant technical element had been created by me alone. Ryan's sales work had generated revenue, but revenue generated from someone else's technology does not create ownership of that technology. That distinction was not a close legal question. Through those weeks, I kept working. I still had access to my original development environment and my own codebase, and I used that time to begin quietly building the next version of the platform independently. I was not going to let the legal process be the only thing moving forward. While Conrad handled the case, I handled the product, because the product was always what this had actually been about. Ryan had wanted the money and the credit. I had always wanted to build something that worked. By the time the legal process reached its next critical stage, I had already done something Ryan had not expected me to do. I had reached out directly to 3 of our largest clients, explained the situation honestly, and told them that regardless of how the legal matter resolved, I intended to continue developing and supporting the platform they had built their operations around. All 3 of them responded within 48 hours. All 3 said they would follow the product wherever it went. The legal process moved into formal discovery, and that was where Ryan's position began falling apart in ways even he couldn't talk his way out of. Conrad's team subpoenaed the communications between Ryan and his Miami attorney going back 14 months. What came back was a paper trail that removed any remaining ambiguity about what had happened and when the decision to do it had been made. The email showed that Ryan had first contacted the Miami firm 8 months before the signing meeting, not 2 weeks before, not 1 month before, but 8 months. The earliest messages discussed how to structure a company reorganization that would reduce a co-founder's equity stake without triggering a legal obligation to notify that co-founder directly. There were drafts, revisions, and follow-up questions that built toward exactly the document I had been handed on page 7. Ryan had not made a rushed decision under investor pressure. He had spent the better part of a year planning it. A separate thread showed the conversations between Ryan and Garrett Holt that had taken place before the formal pitch meeting. In those messages, Ryan described himself as the sole founder and primary architect of the platform. He told Garrett that a technical contractor had assisted with early development but was no longer involved with the company. That contractor was me. My brother had described me to his investor as a contractor who had already been paid and moved on. Conrad submitted the full discovery record to the court along with a renewed motion asserting willful misappropriation rather than negligent oversight. The distinction mattered because it changed the scope of what I was entitled to pursue. This was no longer a dispute about an informal agreement between two people who had remembered things differently. The documentation showed a deliberate, months-long effort to strip me of ownership before I ever had the chance to object. Garrett's team had already seen enough. Within a week of the discovery submission, they issued a formal statement withdrawing from the investment entirely and citing material misrepresentation by the company's represented founder. $2 million gone. The deal Ryan had spent a year building toward dissolved in a single paragraph of legal correspondence. Ryan called me the evening after Garrett pulled out. He didn't leave a voicemail this time. He sent a single text that said he wanted to meet in person and that he had things he needed to say that couldn't be handled through attorneys. I showed the message to Conrad, who advised me to decline and keep all communication formal until the case resolved. I followed that advice. There was nothing Ryan could say in a coffee shop that would change what the documents had already said in court. The case settled 6 weeks later. Ryan did not contest the core intellectual property claim. Under the terms of the settlement, full ownership of the platform, its codebase, all associated patents pending, and all existing client contracts transferred entirely to me. Ryan received nothing from the company he had tried to take. His equity, his board position, and his role as CEO all ceased to exist on the same day the settlement was signed. He also agreed to a non-disclosure provision that prevented him from representing himself as a founder or co-creator of the platform in any future professional context. I signed the settlement documents on a quiet Wednesday morning in Conrad's office in Los Angeles. There was no ceremony to it. I read every page carefully, signed where I was asked to sign, and shook Conrad's hand on the way out. The company was mine again, fully, legally, and without condition. I drove home along the 91 freeway with the windows down and let myself feel the weight of everything that had happened over the previous months. The betrayal, the fear, the weeks of uncertainty, and the slow grinding work of proving something that should never have needed to be proven. None of it had broken me, but I wasn't going to pretend it hadn't cost me something real. Trust mostly. And time I was never going to get back. But the product was still there. The clients were still there. And for the first time in a long time, the path forward belonged entirely to me. The first thing I did after the settlement was call each of our clients personally. Not through email, not through a company announcement. I called every single one of them and explained what had happened in straightforward terms. I told them the legal dispute was resolved, that I was the sole owner of the platform moving forward, and that the product they had built their operations around was stable, protected, and going to keep getting better. Every client stayed. Not one of them left. The second thing I did was hire. I brought on 2 junior developers I had worked with briefly at my old job in San Diego, both of them sharp and hungry for the kind of work where they could actually see the impact of what they were building. Having other people in the room changed the energy of the work in a way I hadn't expected. The months of fighting had been isolating in a way I hadn't fully acknowledged while I was in the middle of them, and building something alongside people who were genuinely excited about the product reminded me why I had started in the first place. Within 4 months of the settlement, revenue had grown 30%. The platform update I had been quietly developing during the legal process launched cleanly and received the strongest client feedback we had ever seen. 2 new logistics companies signed on after hearing about the platform through referrals, neither of whom knew anything about what had happened with Ryan, and both of whom became reliable long-term accounts. Word about the case had spread through the industry in the way that things spread when a story is specific enough to be interesting and clean enough to be repeated accurately. A journalist at a mid-sized tech publication reached out asking if I would be willing to speak on the record about building a company as a solo technical founder. I agreed to a short interview and said nothing about Ryan beyond confirming that the company had gone through a legal dispute over ownership that had since been resolved. The article ran under a headline about women in logistics tech, and the response to it brought in more inbound interest in 2 weeks than we had seen in the previous 6 months combined. I didn't enjoy any of that the way I might have enjoyed it under different circumstances. The recognition felt deserved, but also slightly hollow, because I knew how much of my energy over the past year had gone into recovering something rather than building something new. That distinction mattered to me even if it wasn't visible to anyone else. Ryan had gone quiet after the settlement. I heard through a mutual contact that he had taken a sales role at a mid-sized company in Atlanta, that the non-disclosure agreement had made it difficult for him to explain his most recent experience in interviews, and that the professional reputation he had spent years building in the logistics tech space had taken damage that was going to be hard to repair. I didn't feel satisfaction hearing that. I also didn't feel sympathy. What I felt, more than anything, was distance, the specific kind of distance that grows between people when you finally accept that the relationship you thought you had never quite existed in the form you believed it did. My parents called me around that time. They had known something had happened between Ryan and me, but had stayed out of it while the legal process was active, careful not to say anything that might be used against either of their children. Now that it was over, my mother called on a Sunday evening and asked if we could talk. She didn't defend Ryan. She didn't ask me to forgive him on any particular timeline. She just said she was sorry for what I had been through and that she was proud of how I had handled it. That call was harder than I expected it to be, and I stayed on the phone with her for almost 2 hours. Ryan reached out 6 weeks after the settlement closed. He sent a long email that I read once and did not respond to immediately. He said he had made decisions he couldn't justify and that he understood if I needed time. He didn't ask for anything specific. I sat with that email for several days before writing back a short response that said I had received it and that I wasn't ready to have that conversation yet, but that I appreciated him sending it. That was the truth. I wasn't ready. But I also wasn't closed. 6 weeks after the settlement closed, I filed a separate civil claim against Garrett Holt for knowingly participating in a fraudulent ownership restructure. Conrad had advised me early on that Garrett's exposure was real. The discovery emails had made clear he understood exactly what Ryan had represented to him and had chosen not to ask questions that might complicate the deal. His attorneys contacted us within 10 days of the filing. They did not want a trial. Neither did I. The settlement with Garrett covered my legal fees in full and included a written acknowledgement that the platform's intellectual property had belonged solely to me at the time of the proposed investment. That document mattered more to me than the money. Ryan's professional situation deteriorated faster than I expected once the case became part of the public court record. The non-disclosure agreement prevented him from explaining his departure from the company, which meant every background check and every serious employer conversation eventually hit the same wall. 3 opportunities he had been close to closing in Atlanta fell through in the months after the settlement. A former colleague told me Ryan had started describing himself in interviews as an independent consultant, which was the only framing that didn't require explaining the gap. I also contacted the 3 conference organizers where Ryan had spoken as a founder and co-creator of the platform. I sent each of them a copy of the court record along with a short letter requesting that his speaker profiles and session recordings be corrected or removed. 2 of them responded promptly and took down the content. The 3rd updated his bio without acknowledging my letter directly, which was enough. The last thing I did was send a formal letter to every client Ryan had signed during his time with the company, documenting the legal outcome and confirming that all contracts, data, and service obligations were now held entirely under my ownership. No client was surprised. Several of them had already heard pieces of the story through the industry. What the letter gave them was clarity, and clarity was something I had learned to value above almost everything else. By the time all of it was finished, Ryan had lost the deal, the company, the clients, the speaking record, and the professional reputation he had built in the one industry where our product had made a name. None of it had required me to raise my voice or act outside the law. The case had done the work, the documents had done the work, and the truth had done what truth does when you give it enough room and enough time.